Welcome to Ready, Get Set, a series of 5 videos giving Black and racialized youth and their families a better understanding of the justice system and how to navigate it. The 5 videos are Roadmap of the Justice System, Words You Hear in Court and Their Meaning, How Community Supports Can Change Your Outcomes, Tips on Choosing a Lawyer, Your First Court Appearance. This video is Roadmap of the Justice System.
What happens after an arrest? Could you kind of like walk us through these steps and what is needed to be taken into consideration through this process?
Okay. So police contact, there's a few stages here. When police contact happens, sometimes it's fortunate that people are witnesses, they're around, they can get a call to counsel as it's happening, and then counsel can intervene. There's been times where I've been able to intervene and say, oh, what's going on? Speak to the officer, and things may take a turn for the better. The other aspect is police contact happens. Now, from my perspective, the initial police contact is a key indicator of how everything else is going to go. If you have youth that are nervous, scared, worried, or even acting certain ways because of perceived guilt or factual guilt, you may have a negative police contact. If you have youth that are informed, respectful, communicative, then you might have a different result. So police contact is obviously, first point is one of the most impactful points, and it could dictate the rest of your path. Next, what is that? Arrest charge.
Yeah, arrest charge by police, yeah.
Okay. That's something that the client or the accused has no control over. The police are going to lay the charges that they feel are relevant. I would advise not trying to explain your way out of something, because all you're doing is providing more evidence at a trial that may be helpful or not helpful to you. So there's generally no way out of a charge once a charge starts.
Okay.
The only way I would say you ever speak on something is if there's absolutely, like, I wasn't even here. I was at work at 5 o'clock and you're talking 5:30, and then you're stopping me here at 5:30, and you said the crimes happened at 4:58. I was at my office, so you can, or I was at wherever I work. That's the only time I would speak, is when you have an absolutely clear alibi that can't be contested, that has no other thing than the truth, and proof is there. But otherwise, other statements you make could be detrimental to you. Bail hearing. This is where youth really need to think about, or families need to think about, who are potential sureties, who can assist them, who is responsible, stable, able to supervise, without a criminal record. Those are the people that you want to think of off the bat. Some people have a lot of people like that around them, and some, unfortunately, some youth have nobody around them like that, and they get into a real bind. But that's what you need to be thinking of when it comes to bail hearing. Who is going to bail you out? And then also something to consider is, if the charges aren't that serious, you should be out on your own recognizance. I've had many clients who are youth be released on their own recognizance, even in very serious matters. If you have no criminal record, the charter and the criminal case law standard is you're released without conditions. That's the default position. The only time you start getting conditions and more restrictions is when you've already been released and you've breached conditions and you've been shown, or allegedly shown, not to follow court orders. That's when you get more complicated. Next, going into first court appearance. First court appearance is generally uneventful. It's really just a check-in point. Usually counsel will get disclosure at your first appearance, and that's where the actual trial process is starting. Now the Crown has provided your lawyer with information, and you start reviewing that information to see what evidence is against you. That's where you have a chance to say, look, there's no evidence here, this case should be gone. Or you say, oh yeah, this is a pretty clear-cut case. They have video evidence and it's very clear of this. And then you have to probably start understanding, what are you going to do to mitigate it? Are you going to plea early? Are you going to provide an explanation, try to get a diversion? Those are the things that go through the mind there. And that's where a person like Jody would come to place in her experience with that. So after the first court appearance, you have quite a few court appearances, and you have stages where you are reviewing disclosure. Well, first, you have to make sure you have counsel. And one of the most important things I would say to all youth, for the benefit of youth, is ensure you have the right counsel for you. Far too often, I hear stories of counsel who are there and the youth don't understand what's going on. They're being told to plead to charges. They are not informed of what the disclosure contains. They're not shared information. And yes, I'll admit, lawyers' offices can get very busy where it's very cumbersome for lawyers to stop and do all these things. But this is why, first of all, lawyers are being paid by the clients. And this is why you have representation, for your representation to represent what you want. So that communication is so important. And it's very unfortunate to see accused not ensure that their counsel is informing them or their counsel is explaining things to them. That's something that has to be done. So if you come across a lawyer that is dismissive and is not going to help you or not explain to you and try to tell you, oh, this is how it's going to be done, I'm telling you, you don't want that lawyer. You want a lawyer who's going to listen to you, explain things to you, and be patient with you, because this is your life, not their lives, and they're there to represent your interests. So they have to understand you. So you go through a bunch of Crown pre-trials. Okay, so what happens is the evidence is reviewed, and then there's something called a Crown pre-trial where you meet with the prosecutor and discuss the elements of the case. At that point, the prosecutor may say, well, tell me what's going on with this kid. I see this as a minor offense. We might divert it, or we might withdraw it, right? And then that's where you have the chance, or the accused has a chance to demonstrate whatever's going on in their life. On the vice versa, it could be, oh, this is a horrific crime. There's tons of evidence. Your client's going down. We're doing everything we can. We have serious concerns. And then that's where counsel has to explain to the client, this is the evidence against you. What do you want to do? That once the Crown pretrial is over, the next stage is called a judicial pretrial. If the Crown decides to withdraw or resolve, or you decide to resolve, it doesn't go any further. You make arrangements. You say, okay, we're going to do a plea, or we're going to withdraw, etc. If it goes forward, you get to a stage called a judicial pretrial, where you sit down with the judge, whether your lawyer will sit down with the judge, the Crown, and your defense counsel, and they will all discuss the witnesses, how long the trial is going to take, and any possible issues such as charter issues, if the search was done illegally or if the stop was done illegally. That's all factored in, so you can get a time estimate. And once you get that time estimate, the judge, the Crown, the defense all agree this is going to be a 4-day trial. So you go to the trial coordinator and you schedule a 4-day trial. Then on the day of trial, you start your trial, and all that proceeding takes place. After the trial, if you are acquitted, great. If you're convicted, unfortunate, or deserving, depends on the circumstance. But that stage is now evaluating what is going to be the sentence for the accused. This is a very important part, because the youth have to understand that everything happening in their life, if it's led them to a path where they've shoplifted or they've committed an assault because they have a very low threshold for something, or they have a mental health issue and it's explained why they've acted in a certain way, that's the chance to put that all on the table so the judge can evaluate what your appropriate penalty is. Youth under the Youth Criminal Justice Act are very clearly defined as having a decreased moral blameworthiness, which means at a young age, you do things that are impulsive. You may do things that don't make sense, but that's because you're young. And that factors into your sentence. That's considered, as opposed to an adult who's mature and you can evaluate. Youth don't evaluate the same way. It's not an excuse for bad behavior, but it is a factor. When you put all those factors together, the experience, the age, any positives such as graduating high school, working, supporting other people, those things all get put before the judge, and the judge will decide what's an appropriate sentence. The Crown, if you can put all these things before the Crown early, the Crown may say, hey, this is a great kid, I'm not asking for much, maybe we can go in joint. Joint is a secure way of almost guaranteeing you know what's going to happen. If the Crown and your defense lawyer agree that 20 hours community service is enough for what's happened, Then they present it before the judge. They say, you know, this is the sentence. We're proposing in joint position, 20 hours community service. Judge will say, I agree. However, just always be aware that a judge may view the situation differently and say, you know what, you guys are being way too lenient. I think, 50 hours community service, or I think this is appropriate. So it's never guaranteed when the Crown and defense agree. The judge always has the ultimate decision.
This series has been developed by Delta Family with support from the Ministry of the Attorney General and partners. Delta Family provides culturally relevant free youth justice and counseling services to Black youth and families and has served diverse communities in Northwest Toronto for 40 years.